Okay, I'm going to push on with the third video in this series on capitalization and budgeting in an idealistic plaintiff side practice. And as I've said in the prior videos, this video links to an essay that's on my website that has to do with these issues and gets into all this stuff in a little more granularity. And the point of doing all this is just that there isn't that much information out there about these budgeting and capitalization issues in plaintiff side practice. And I think it's interesting. So I talked in the prior video about this idea of a plateau, this notion that you can win individual cases and come out ahead and yet ultimately not develop a practice that is sustaining. And one way to look at that plateau problem is looking at the scenario of a existing practice, the cash going in and the cash going out, and how that practice would sustain an attorney. Later on, I'm going to talk about the startup issues related to a practice, and those are something that Pratik Shah, the attorney, has emphasized in his podcast. But before we get to that sort of startup trough problem, let's just talk about the scenario of an existing practice and the types of values that that practice might be bringing in. As I've said, I've came at this from a relatively idealistic slash naive perspective. And I just thought, well, I'm going to work on a couple cases every year that have interesting constitutional issues in them, and we'll just see where that goes. And when I say a couple cases that have interesting issues in them, another way of talking about that is those are sometimes relatively low value cases viewed against the continuum of all possible cases. Civil rights cases can range in value really widely. They can be nominal damage cases where the damages are only $1, but they can also be cases that are worth millions of dollars if an individual is killed or if the behavior of government actors is really egregious, such that punitive damages are at play. Those cases can easily be multi-million dollar cases. And so in the essay, I posit that one could talk about low value cases as being in the $50,000 range as a settlement. I mean, a middle value case might be a $200,000 case, and a higher value case would be in the $1 million range. And if you assume that the lawyer's fees are 33%, then you can come up with what a low, a middle, and a high value fee would be for the lawyer in each of those scenarios. And I spell it out in the essay, but it's $16,500 on the low value, $66,000 on the mid value, $330,000 on the high value. And the point of that is just thinking about the fee and how it maps onto the case starts to let you think about, well, how many cases would you have to have in a portfolio in order to have cash flow that made sense for the practice? And I emphasized in the essay that it's interesting that high value cases are not just worth a little bit more than low value cases. They're worth radically more, right? The $16,500 that a lawyer might get for working on this low value case doesn't compare to $330,000 that the lawyer would get for working on a $1 million case. Those are just in leagues apart, orders of magnitude apart. But the work involved in a low value case versus the work involved in a high value case doesn't necessarily scale up the way that the payout does. In other words, it can be just as much work and sometimes even more work to process a low value case as it is to process a high value case. And it depends, but sometimes a high value case is one where the facts are so egregious, the damages are so obvious that it's not some great feat to persuade the defense that there needs to be a settlement or to persuade a jury that a verdict is appropriate. Sometimes, liability will be acknowledged in those cases, and you're really just arguing about the valuation of the case. Also, costs don't scale up as dramatically as the valuation of the case does, because every case involves filing fees, service fees, and probably discovery. Whether the case is worth $100 or $10 million, those things are going to be true. There's still going to be those costs. And there may be more complex expert issues in more complex cases, and those can be substantial costs. However, as I discuss in the article, in any settlement, in any contract that describes how costs are recovered in a settlement, the contract's normally going to say the costs are going to be recoverable to the lawyer. So it's not necessarily some serious hit to the lawyer to have more costs come out, because those costs are going to come back anyway. All right. So I talk in the article about how a portfolio of just these base hits, low value cases is a way to be stuck in this plateau. And the example I give is, well, suppose you have 10 or 15 cases in a portfolio, but they're all low value cases. And I'm not going to get into it here because it's not a good thing to talk about, when it's so much numbers, but I'll put it up on the screen. Just the notion is that if the cases are only low value cases, even assuming very modest numbers on operation costs, like if the practice is mostly remote and the costs are extremely low, nevertheless, the net to the firm doesn't really even begin to keep pace with salaries for whatever sort of idealistic position you might care to say, the public defender salary, working at the ACLU, or anything like that. This type of base hit practice is going to net out lower than all of those alternatives. But it's going to be a lot of work. It's going to be a lot of work, and it's going to tie up a lot of capital. And so that practice is economically not such a great thing. Now, it may be worthwhile, nevertheless, and it may be fulfilling for the lawyer. It's just that the economics of it are considerably worse than alternatives in the legal marketplace. And so then I talk about a couple different alternatives for getting out of this base hits model. And I'm not going to spell out numbers here because it's not a useful way to use a video format. But one alternative that I talk about is to pump up case volume. And in order to pump up case volume, you got to advertise, you got to bring on support staff. But the point is that when you pump up the case volume, because the costs are mostly recoverable, you're going to start to get a significantly higher net. But that kind of case volume is not probably consistent with the more idealistic model of doing the work, because the reality is there might be lots of car crashes out there or lots of slip and falls out there that you can potentially draw into the firm to make a big case volume. And that's why you see these guys with the billboards and the bus advertisements and so forth. But there aren't lots and lots of interesting constitutional cases or interesting cases involving police conduct or whatever sort of civil rights issue or whatever type of interesting, engaging problem. There aren't tons and tons of those cases. There are some. In any metropolitan area, there are going to be some, or even in a rural area, there are going to be some. But it's not like you can crank those through a system. At least I don't think you can. You have to be realistic about the fact that those are just somewhat marginal problems that occur from time to time, and they need to be addressed, and hopefully they can be litigated in a serious way. But it's not like car crashes, where car crashes are just happening all the time as sort of an ambient feature of our an ambient feature of our society. So anyway, this alternative, that what I'm calling the PI model, I don't think is really that well suited to an idealistic practice, even if it is a way to generate higher case volume. You say, well, I'm going to start taking on those slip and falls. I'm going to start taking on the car crashes. I'm going to start taking on premise liability cases from wherever, or whatever other sort of case model in which lower volume case or lower value cases come in, but in a higher volume. All right, alternative two I'm suggesting is what I'm calling pursuing the home run, and that's by taking the cases all the way to trial. And again, without getting into the numbers, the point of this is that under most theories in which civil rights cases are litigated, there's potentially a fee shifting aspect to the case if you prevail at trial. Now, that doesn't always come to pass, depends on the law, but assuming we're talking about a federal civil rights cause of action or some of the causes of action under California law, that can be the case. And so even if the case value is relatively modest, say it's $10,000 or even $1 in a nominal damage case, it could trigger a attorney fee award of tens of thousands of dollars or even hundreds of thousands of dollars. And that home run aspect of the case could then finance other cases going forward. And one aspect of that I think is important to emphasize, that I don't see discussed a whole lot in the world of plaintiffs' attorneys for whatever reason, is that the decision to go to trial is not the lawyer's call to make. And I'm a little bit frustrated with the culture of plaintiffs' attorneys who are constantly beating their chest about how they go to trial. Even though trial is good, trial should occur if the client wants it. And it's the client's call to make if there's an offer on the table. And I've heard anecdotes about plaintiffs' attorneys tearing up offers and things like that. And I just think that's absurd, because none of this is about the ego or the prowess of the plaintiff's attorney. It's about the interest of the client. So anyway, that's my soapbox. But the decision to go to trial or not, if there's an offer on the table, is up to the client. But anyway, assuming that the client is willing to go through the stress and aggravation, which is not minimal, but assuming they're willing to go through that and go to trial, that does open up the possibility of this home run type scenario where the lawyer can potentially come out pretty well. However, it also opens up all kinds of complications based on post-trial motions and appeals and blah, blah, blah. That's the system we operate in. The point is that going to trial can be a lever, an economic lever. And then finally, the third alternative that I talk about in the little essay is kind of a hybrid model where, yes, there are these cases coming in from time to time, and they're worth what they're worth, but the cash flow is being sustained month in and month out from some other means. I mean, a lot of civil rights attorneys are also doing criminal defense. Some of them do PI. You could be an academic. You could work at a nonprofit. The idea is perhaps there's a way to have some other form of money rolling in relatively frequently, such that the civil rights cases don't have to be this conveyor belt of cash in order for the practice to be viable. And as I've said in the other videos, I've done post-conviction work for a long time, and I continue to do that work because I think it's interesting, but it also incidentally helps pay my bills as I'm working on these other cases. So that's that for now. Just this notion that the costs are recoverable, but you have to think about what the realistic payout is of a given portfolio of cases once the portfolio is established, and how that annual payout maps onto whatever your expectations might be about what you think you need to live. And I'm going to get into, in the next video, the question of this capital trough that is involved in startup, but that is sort of a separate issue from just this general question of like, well, assuming the practice gets up and running, how much is it going to generate? And so I hope that's somewhat helpful. And as I say, please check out the essay for the specifics of the numbers that go along with all of this. And I will talk to you in the next one about the capital trough.